Last week, the Speaker of Parliament, Alban Bagbin, directed the Roads and Highways Minister to retract the statement on the cessation of road tolls. He sternly stated that the minister had no power to do so. This was after the minority leader described the action as one usurping the powers of the Parliament.
I am submitting strongly that this House must take a serious view of the conduct and directive of the Minister for Roads, as is an attempt to usurp the powers and mandate of this august House. And Mr. Speaker, to suggest as if this country is not governed by law, it cannot. Whilst he has every right to be in a hurry, to listen to the President's directives to be in a hurry, he cannot be in a hurry to usurp the mandate of this House and be in a hurry to revise a legislation that this august House have not so approved.
So it's for us to draw his attention and tell him that you have no such authority. In spite of all the legal and linguistic gymnastics that have been displayed, it is very clear that what the minister sought to do, he has no such authority to do that. It's not a matter of operationalization of the law. And so I want to clearly direct that what the minister has released is complete brutum fulmin. It means it's an empty boast. It has no effect. So I think that it's proper for us to direct the minister, a member of this House, in fact, a senior member of this House. He's not just a junior member, he's a senior member of this House who is used to all this. And I think that he might have reacted wrongly. And therefore, I call on him to honorably withdraw that directive.
The majority leader, however, disagreed with the Speaker, questioning his authority to direct a Minister of State in that manner.
The minister wanted to save the situation as to whether it conformed to legality. That was another matter. That is another matter. But the minister acted tirelessly to save life and property. Mr. Speaker, that is why the directive was not about the suspension of the law. The minister could not have suspended the law. He only dealt with the operationalization of the law in place.
Shortly after that, the Buakwa South MP, Samuel Atachia, said the Speaker had no power to cite the Minister for contempt of the House.
I am of the humble view that this is not a resolution of Parliament. Parliament did not resolve that the Minister should retract his statement.
No, but the Speaker was clear.
The Speaker says so.
Yeah.
But the Speaker is not Parliament. You see, a resolution of Parliament is a decision taken by the House.
But the Speaker is the head of Parliament, isn't he?
He's a referee, but he doesn't give directives to Parliament as to ethics. He will sit in his office or say that this is my will. The will of Parliament should evolve from the members of Parliament via a resolution. To that extent, I'm of the view that there's no resolution of Parliament that has been handed down, the disobedience of which will amount to contempt of Parliament. What is worse, mind you, this is where the laws of this nation is made.
Right.
And to condemn a man without hearing him flouts the natural justice principle. It's called the Aldi Alterum Patem principle. So therefore, if you look at it from the perspective that the minister was never heard, then a judgment against him without hearing will not stand in law. And that is very, very unfortunate.
The minority described the utterances of the majority as an attempt to undermine the authority of the Speaker. It's exactly a week since the Speaker ordered the Roads Minister to retract the cessation of road tolls. Clearly, the Speaker's directive has been ignored. Will there be a bite after the back.
Welcome. This is The Law. It's your legal light. It's your help law. I'm Samson Ladi Anyanini, and my guest this afternoon, Julius Opoku-Adjei, is head Opoku-Adjei and Company, and Musah Ahmed, also head Ahmed Legal Consults. And what are we looking at? The legality of the toll suspension and the budget rejection. Two things happening within Parliament. The Speaker, as you just heard a while ago, was so unhappy, together with the minority, complaining about the Roads Minister's power to issue a fiat that suspends the operation of tolls a day after the budget was read. And as you may have followed so far, Parliament is said to have rejected the budget for 2022. A number of issues have come up regarding that. Is the rejection valid in law, or it is, as we say in law, null, void, and of no effect? Three things put together the same. So let's get to look at the issues now. And as you know, as always, we will have you join us to share your views on the matter after the lawyers have educated us. So thank you, Mr. Opoku-Adjei, for making the time to join us.
Thank you.
Great.
For having me.
Great. Musah Ahmed will join us shortly, but before he does, let's begin by looking at the issue. What would you say? Does the minister have such power, or he does not have, as the Speaker, informed us?
The minister, as far as I can tell, does not have the power to change legislation in the manner in which we believe he did. Now, the fundamental question to be answered is, what did the minister do?
Right.
There is a Road Tolls Act, a Tolls Act. There is subsidiary legislation which has been passed stating which roads are to be tolled, subsidiary legislation stating how much tolls should be collected. The minister wrote a letter asking for the suspension or for the seizure of the toll collection. Does that amount to a revocation of the act or the legislative instrument? That is the problem that I see. If the minister's act amounts to a revocation or, let me put this, a withdrawal of the legislative instrument, then the minister has no such power. He has power to pass legislation, to make the LI to impose the toll, determine how much or where it should be tolled. He has power also to revoke it. But that power can only be exercised by an LI, in the same manner in which the toll was imposed. It cannot be done by a letter.
When you say he has power, where does he draw that power from, or what power are you talking about?
It is from the Act, the Tolls Act. The Tolls Act gives the minister power to, the Tolls Act is NRCD 153.
Okay.
It gives the minister power to impose road tolls. And by our constitution, and the tolls are imposed via legislation that the minister will put before Parliament, LI, legislative instrument.
Right.
And by our law, where a person is given power to make an act, that same person impliedly has the power to revoke that act. But the question is, by what procedure do you impose the act or make the law, and by what procedure do you withdraw or revoke the law?
Okay.
That is the issue.
So let's take our audience through maybe, is it Legal Methods 101? That the act you talk about, which imposes the toll, or which gives the power to the minister to, by the power of an LI, that is a legislative instrument, impose a toll or determine which places we can impose a toll. Because that is an act, that is law made by Parliament. That's correct?
That's correct.
That's law made by Parliament. And in that law made by Parliament, they have given the minister power to do an LI. And that LI, legislative instrument, he cannot do it also by himself.
He must go through Parliament.
He must take it to Parliament, according to, is it Article 11? Okay. He must take it to Parliament, and when he takes it to Parliament, after a certain process, that then becomes law.
Yes.
So that is how we came to pay the tolls.
Yes.
He gets up, he says, a budget has been presented. And in the budget, the decision of the state, of the government, is that we don't want to continue to take tolls. So, budget is presented this afternoon. He writes a letter that the next morning, tolls should not be taken. If you say he was giving the power, why are we, faulting him? What has he done wrong?
In the first place, reading or presentation of the budget to Parliament does not amount to Parliament accepting and passing the budget.
Okay.
So whatever statements are contained in the budget are the intentions of the executive.
Okay.
This is our financial statement. This is what we intend to do 2022. It is for Parliament after debate to accept or to reject it. And we know what has happened. It's one of the things we are going to discuss. So that hasn't been done. However, that notwithstanding, the minister, because he has the power through legislative instrument to make a road a tollable road, can also untoll or revoke that. So without even waiting for the budget to be passed, he could have presented the LI to Parliament, revoking the LI by which the tolls were imposed. That was not done. And that is where I find fault with his actions. I've heard explanations about it being an administrative measure. Yes. I don't agree with that school of thought. You have stated clearly that this is what the budget has said. And you are complying with what the budget has said when the budget itself has not even been accepted.
Okay.
When the budget itself has not even been accepted. What if, at the end of the day, the budget is amended to keep road tolls at a different rate? What happens?
I'll be asking you to tell us, for example, in 2006, a law was made that said Ghanaians who live abroad have been given the right to be registered in abroad for purposes of voting and to vote from wherever they are in abroad. The state has not operationalized that law. What has Parliament said? Has something unlawful been done in that regard? There's a question that's been asked in that regard. But to start with, and this is for the purpose of the education we want you to have. And as you will know, on this show, even though these issues we are discussing this afternoon are very political, we deal with them from the legal lens, without the politics. The Constitution of Ghana in Article 11 provides for the laws of Ghana and the hierarchy of the laws. So the Constitution is the first. It overrides all other laws. Next to the Constitution is what you call the Acts of Parliament. Then, next is what we may call the regulations and orders.
Subsidiary legislation.
Exactly. So, Constitution is first, laws made by Parliament as acts second, in that order of importance. And then Parliament makes the law and gives the minister power. But that power to determine which roads will be tolled, he has to go back to Parliament. And the law says when he brings the LI to Parliament, it will come into force at the expiration of 21 sitting days after it has been laid.
That is Parliament's mode of supervising the power it has given to the minister.
Right.
That's why the minister cannot sit in his ministry and together with the Attorney General only turn that power into law.
Okay.
It must come back to Parliament, sit in Parliament for 21 days, and if nothing is said about it, it becomes law. If there is an objection, the whole thing goes back to be redone and then brought back.
Once it became law and it is in operation, if the minister, who has the administrative power to collect the tolls, gets up one day and finds that there's a difficulty, I can't collect the tolls, and he says, I've suspended it, what wrong has he done?
Samson, this is a tough one. If he wakes up one day and finds out, for instance, that he doesn't have sufficient staff to collect the tolls, can he be said to have revoked the law? No.
Okay.
He cannot. If he finds out that the equipment for collecting the tolls are faulty, and so he says that, look, let's hold on until we're able to repair or get new equipment, can he be said to have faulted the law? In my opinion, no.
Okay.
But if he gets up to say that I am suspending toll collection because it is the intention of government to suspend toll collection, then you are going before the law is revoked. The law has been made. Your difficulty is that you have an intention to revoke the law. You haven't done that. So, in my opinion, you cannot then say, I will not collect the toll because I intend to revoke the law. The law has not been revoked.
Okay. So you say on both counts, if the intention is that he is suspending it because government has submitted a budget that doesn't want to collect tolls anymore, he's wrong because the budget is only a proposal, has not been approved.
Yes.
If it is the case that he is doing it without reference to the budget,
yes,
once again, he's wrong. He cannot use a letter administrative process.
He cannot use a letter, but notwithstanding the budget,
okay,
he could have presented an LI to Parliament to revoke toll collection,
right,
in spite of whatever happens to the budget.
Before I go to Musah Ahmed, why is it important to follow such an elaborate process when you can easily use, as it were, a letter like he did to simply cancel the law? Why is it important?
Remember I said that, or we all agreed, that Parliament is the only body which can make laws in Ghana. Parliament has ceded some of its authority under subsidiary legislation to ministers, and that is by law, by operation of law, to pass these subsidiary laws. But Parliament retains its oversight responsibility. That is why the LI, when it is drafted, must go to Parliament and sit there for 21 sitting days before it becomes law.
Okay.
So when you sit outside Parliament and change or purport to change the law, you are circumventing the supervisory powers of Parliament to ensure that there's a subsidiary legislation it has given you. Don't forget that it is Parliament which has given you, of course, by operation of law, that's power to make law. You are circumventing their rights and their duty to supervise your lawmaking activities.
Okay.
We cannot accept that.
So, do we have Musah Ahmed on the line? Great. Good afternoon, Senior.
Good afternoon.
Good. Now, we have just been, shown what the law is. In Article 297, it says, and I read, in this Constitution and in any other law, the power to, it says, where a power is conferred or a duty is imposed. No, that's not the one I want to read. The one I want to read is this particular one. It says, where a power is conferred to make any constitutional or statutory instrument, regulations, or rule, or pass any resolution, or give any direction, the power shall be construed as including the power exercisable in the same manner to amend or revoke the constitutional or statutory instrument, regulation, rule or resolution, or direction as the case may be. So if in Section 2 of the Tolls Act, the minister has been given power to, through a legislative instrument, impose the toll, and he determines at a point that the state doesn't want to do it again, and he issues a letter to cancel it or stop the collection, what wrong has he done?
Thank you very much. When you read the language of the provision, you would, the language was carefully crafted so as to give it legality, so as to show that whoever exercises that power can only do so in accordance with law. Now, if you want to reverse the exercise of that power, you must, in the same vein, do it in accordance with due process of law. Due process of law in the sense that you cannot just by a fiat, by means of a letter, revoke what you use a due process of law to enact. Even Parliament cannot just simply sit down and revoke a law. They have a procedure by which a law can be amended, a law can be revoked, additions can be made, and therefore, the minister's purported letter, in my opinion, was a mistake on his part. And I think it is never too late to do the right thing. He should go back, contact his lawyers, in fact, consult the Attorney General, who under Article 88 is the chief legal advisor to the government, to advise the minister. In fact, all this brouhaha that has been going on, people talking and some are supporting, some are not supporting the minister. Let us do this devoid of any political leaning. I haven't heard the Attorney General come in to say anything because the Attorney General is a lawyer and he knows that the right thing must always be done. In my opinion, the minister should, and it is not too late, he should consult the Attorney General as to the proper thing to do. Because he cannot just by a fiat, by a letter, purport to revoke it, especially so when the decision was contained in the government's budget. He passed by Parliament, and the minister himself had indicated in the budget statement that subject to parliamentary approval. So what was the rush for?
People are excited. They love the fact that the tolls don't exist anymore. So as far as they are concerned, we don't want the tolls. What is all this legalese about? What is it about?
Yes, the people may be excited. I myself am excited when I use the toll booths and I don't encounter the usual traffic I used to encounter. But my point is that we should not create a precedent of disorder. We should not create a precedent of lawlessness. We should not create a precedent of dictatorship. We should not create a precedent where people think they can just do anything anyhow and go scot-free. I like the minister as a person, and I like him because he's a hard-working minister. But I think he goofed at this time. He should consult the Attorney General, who is the chief legal advisor and who is a professional lawyer, to advise him to do the right thing. We cannot allow a situation like this to happen. Is
it something that is unheard of, or as you say we should pay attention to the language of the law? And I'm referring once again to Article 297D. It says that where a power is conferred to make any constitutional or statutory instrument, regulation or rule, or pass any resolution or give any direction, the power shall be construed as including the power exercisable in the same manner to amend or to revoke the constitutional or statutory instrument, regulation, etc. So you are saying that because the law says you can undo what you have done in the same manner you did it, if you don't go to Parliament, then what should happen to you?
You see, it means that you have exercised the law unlawfully. Let me give you a practical example. It is a rule that before you drive a car, you must open the door and enter. Right?
Yeah.
It is also a rule that you cannot just sit in the car and expect the door to open automatically. In the same manner in which you use your hand to open the door to enter, you must use your hand to open the door to come out. That is the rule. Do you understand? In the same way you use the legislative, the processes to pass the legislative, the regulation, use the same method to come out of it. I'm not saying you shouldn't come out of it.
So let me hear you briefly on this, and let's hear Opokwe J2 on it. The speaker said what he did was in contempt of Parliament, and he is a candidate to be punished for contempt. Does Parliament superintend, as in police, our laws, so that if a law is not being operationalized, Parliament can go and say, we want to punish you for contempt because you have not worked according to the law?
Well, the position taken by the Honorable Speaker is subject to various interpretations. Some schools of thought are saying that this is not an issue that can be classified as contempt of Parliament. Some are saying that, well, it could be classified as contempt of Parliament. But in my opinion, I don't think the decision of the minister is clearly in contempt of Parliament. You see, contempt is a quasi-criminal. Now, criminal, you need to look at the elements of a crime. You are looking at the act itself, the intention with which the act was committed. Now, if you cannot put the two together to obtain a balance or their existence at the same time, you cannot say that a crime has been committed. Okay. What the Right Honorable Speaker, the minister has committed an offense.
No, he's saying, the speaker said, what you brought to us is a budget proposal. We have not yet approved the budget. Since we haven't approved it, you can't go and be implementing the budget. That is contempt.
Well, that's why I'm saying that it's subject to debate. The question is whether if somebody infringes a law or a rule, it constitutes contempt of Parliament. Okay. It's one thing. And whether the same act, if it is done, does not constitute contempt of Parliament. I'm saying that in this particular instance, we should excuse the minister for his mistake. The intent with which he did it, the knowledge. We should not just say that he did it openly in disregard to the authority of Parliament. I don't think so.
All right.
In my opinion, I don't think.
Okay.
You can forgive him for that.
All right.
And he must do the right.
Okay. If he doesn't do the right thing, what should happen? Yes, yes, Opokwe, what do you say?
I do not see the minister's actions as contemptuous of Parliament. First of all, he has not disrespected any directives of Parliament as Parliament. Parliament has not issued any orders to him. Parliament has not passed any resolutions, which he has refused to respect. He has sought to, I would say, probably amend our laws unlawfully. A citizen can go to court for a declaration that what the minister did is unlawful. That, I think, is the remedy.
Okay.
I don't think the remedy is citing him for contempt of Parliament.
People have asked whether he could be cited for causing financial loss.
Have we lost money? Yes. All this while we have not been collecting tolls. Was it his intention that he would cause us to lose money? I'm sure he knew that by suspending the tolls, we will certainly lose money. But what was the intent? Was it a willful act to harm the country? I don't think so.
Okay.
I think it is a political act which he thinks will rather promote something in his mind or in the mind of the executive, but which has been done in the wrong manner.
Okay. I was asking earlier that there are laws that are not in operation. Why are we not taking the government on for a similar situation?
Well, it depends on who it affects. I remember that some people have gone to court on this ROPA laws before and gotten orders made in their favor.
That's right.
Some of which I think have still not been obeyed.
That's right.
I remember EC was given certain instructions by Supreme Court. EC went back to court to explain why it hasn't obeyed the court and asked for time to do that.
That's right.
So, when it comes to operationalizing the law, we don't have our executive always being in a hurry to operationalize them. And when a law is passed, we all agree, for instance, if an office must be set up to operationalize the law, that will take some time to do. I mean, between the time that the Office of the Special Prosecutor was passed and now, time passed. But if a law is in operation and you are seeking to revoke it, then I don't think that you can say that because Law 1 is not being operationalized, I can, as a result, withdraw Law 2 without passing through the procedure.
Right.
You cannot do that.
Thank you very much. Okay, so the ROPA case, you know, I did that case. So let's go hear the speaker again, declaring that the budget has been rejected, and come and ask the question whether it is valid, it is constitutional, or it is void.
The results. Those in favor of the request, that's the prayer of the Minister of Finance for more time to do consultation with the leadership, 0. That's nil. Those against the requests of the Minister for Finance for more time for consultation with the leadership, 137. So the noes have it, and the request is accordingly lost. Now I proceed to put the question on the motion. Those in favor of the approval of motion number 11 on the order paper, who says, and I read, that this Honorable House approves the budget statement and economic policy of the government for the year ending 31st December 2022. Those in favor of the motion say aye. Those against the motion say no. Honorable members, clearly the noes have it. The motion is accordingly lost.
On this note, let me begin with Musah Ahmed. What do you say? The questions are rising. Parliament, when it's sitting to do its normal business, requires, according to Article 102, requires 1/3 of all the members of Parliament, and that is 92 of them, of the 275 members attending. But when it comes to Article 104, it says that, except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of the members of Parliament present. Some say, or the majority in Parliament, led by Oseche Mensah, to say that because they had boycotted Parliament at the time, the majority, if you like, the number you needed, more than at least half, was not achieved. So this is invalid. What do you say?
I would want that we put this matter to the court to determine. You see, what we have to ask ourselves, did Parliament use the right procedure in voting or considering the proposal which was brought before them? If the answer is that they used the right procedure, then the outcome, in my opinion, is constitutional and valid. If what the majority side is saying, that they were not present when the decision was taken, it means that they were not present and the requisite quorum constitutionally required to make it valid was absent. It means that the decision that was taken by the minority in the absence of the majority was invalid. But we have two contesting parties here. The majority are saying that this is what happened. In fact, I was not in Parliament. I did not follow the proceedings of Parliament. All that I have seen are those I read in the media. And I know that the media, most of the time, do not represent or they don't present the facts as they existed. So I sometimes get slow at accepting what I read in the media. In my opinion, the majority should take the matter to court. If they think there has been an unconstitutional act on the part of the majority and speaker, I don't want to delve so much into the argument whether it is constitutional or not. For me, we should reserve that question for the court to determine.
Okay, let me hear Opoku-Agyei and return to you. The argument is that Parliament needed, the law says you need at least half. The majority says half of 275 means 138 members.
137 and half.
They say it means 138 members present before you can take the vote. At the time you were taking the vote, you did the counting and you said there were 137. Because of that, it is invalid. What do you say?
Let's go back to what makes Parliament quorate and what can lead to suspension of sitting if they are inquorate, before we come to this. Now, Standing Order 48. 1. The presence of at least 1/3 of all members of Parliament besides the person presiding shall be necessary to constitute a quorum of the House. Now, if there is no quorum, what happens? That is 48.2. If at the time of sitting, a member takes notice or objection that there is no quorum, let's put it that way, then the Speaker has to suspend.
That's right.
That is for a quorum for their normal business.
We have seen them doing this
several times.
Now, and this quorum he's talking about, 1/3, is 92 of the 275 members. Hold on, we'll be right back. You're welcome back. This is The Law. It's your legal light and your health law. And my guest, as we look at the legality of the suspension of the toll and also the legality of the rejection of the budget 2022. My guests are Julius Opoku-Agyei and Musah Ahmed. Yes, so from the quorum, for ordinary things to be done in Parliament, you've just gone that. So what next?
So what this suggests to me is that if a member does not draw the Speaker's attention to the fact that they lack a quorum, they may continue with business. So there might be 10 people in the chamber. If nobody draws the Speaker's attention to that, we are less than 92 or whatever the figure is, they may continue with business.
And as we know, sometimes they do that.
Sometimes they do that. But when it comes to taking a decision, voting, it says at least half must be present. And it doesn't make that same provision that as a member has to draw the Speaker's attention to the numbers or lack thereof of the numbers, all contained in the same standing orders. Does that then mean, that when it comes to the voting, then half must be present, whether or not the speaker's attention is drawn to it. Don't forget that the word used here, now for a question, it says that no question for decision in the House shall, that's mandatory, be proposed for determination unless they are present, not less. So it's mandatory.
And this standing order
108, okay. 1081.
Okay.
From the, I hope it's the correct version I'm using. It's the 2000 version of the standing orders. So does that mean that when it comes to voting,
I think it's the same thing. It's in 109.
Okay.
Order 109.
Yeah. Does that mean when it comes to voting, then we don't need somebody to draw the speaker's attention to the number of people in the House? The House or the speaker himself must take note and see whether you have half or more. That's, for me, is the issue. My interpretation of it is that when it comes to voting, because the law doesn't say somebody must draw the speaker's attention to it, then whether the speaker's attention is drawn to it or not, if the people in the chamber are less than half, a decision cannot be taken.
Okay.
That is my understanding of
the suggestion that the number that says must be present. The suggestion that present should be looked at from the register. That you came in the morning and you registered. So all those who boycotted must be part of the number that was in the House. So there was more than 138.
Let's go back to the wording. No question for decision in the House shall be proposed for determination. When was that question put? What was the number at the time the question was put? Was it 108? Was it 137? Was it 275? For me,
at the time
number,
the question was put, it was 137.
Then that question shouldn't have been put. To have a quorum to start your business, you need 1/3. So you can start your business with 1/3.
There are those who are raising the issue that that number must not be at the time when the voting is going to be made, but must be construed as the number of parliamentarians who have registered as being in attendance.
That's what I'm attempting to delve into.
Okay.
That because you need 1/3 to start business, you can start your business with 1/3 present.
Okay.
But you cannot put the question unless at the time you are putting the question,
you have 2/3.
You have half.
Yes, half
present. Now, does that then mean that if you start the business with the full House, and then members drift out of the House, so that at the time you are putting the question, it's less than half, you can put it? In my opinion, no.
Okay.
Because it says at the time, this is no question for decision shall be made.
So the minority says this is invalid. This is unconstitutional. What does that mean?
The majority says...
The majority, yes.
It is, yes.
Yes.
This is a political question now. Why? The majority can decide to come to the House to rescind the decision that was made. Will they have the numbers to succeed? Don't forget that the budget must be presented within a certain period, not less than a month to the end of the government's financial year. Will they be able to master the numbers? I don't know. I doubt it. Looking at the position of the minority.
So
from then,
the way to undo what they say is an illegality and unconstitutional is to do a motion for rescission.
There are two methods: motion for rescission or go to court.
Or go to court.
Go to court, which will probably
go to court take for how long?
Take even longer. So they are between a rock and a hard place. Either way, I mean, this is not purely law, but the legal options open to them is to either to go with the motion to rescind the decision that has been made, or go to court.
So they cannot get up and go to Parliament the next day and say
the budget that it was never decided.
Have the budget, yes,
because it was never decided.
Yes,
a decision has been made. You are challenging the decision. You cannot say that because, in your opinion, an opinion which I will confess to support by law, there wasn't sufficient numbers for that decision to be made, I would disregard it as if no decision has been made. You cannot do that.
So even though, when you take the view that it's unconstitutional and it is invalid, then you must take steps which is constitutional and which is valid
to set it aside.
Vacate it. Before you can start it all over again.
Yes.
You can't just walk into Parliament and say...
When you take steps and you succeed in vacating it, then the process continues because it doesn't start. Because the debates ended.
Right.
It was the voting, before the voting that they worked out.
Yes, Musah Ahmed, what do you say to that? How do they resolve this? Apart from the suggestion that you made to go to court?
Well, because Parliament is now composed of two parties, if you like, and they are divided. I would agree with my learned friend that when you read the provisions of Article 104 of the Constitution, clearly at the time, the word present used there says at a particular place. So the argument by the minority that some who came to register and left were present should be construed as present is neither here nor there. We cannot accept that one. If in their record we do a head count and the members of Parliament who were present during the voting were not up to half of all members of Parliament, then in my opinion, that decision did not meet the requirement of the Constitution. And it is null and void. Now, my learned friend has also clearly explained that when a decision is null and void, it does not mean that it can be ignored. You can't ignore it, because if an order is considered to be void, you must take a step to set it aside. It's
Parliament court. It is the court that we know that the law ex parte affoda. It says that, if you think that something is unlawful, or a judgment is unlawful, or an order is unlawful, you can't disobey it. You must first go and have it set aside. Else, if you disobey what you think is unlawful, you will be found guilty of contempt. Is Parliament a court?
Parliament is not a court, but Parliament exercises powers which sometimes are akin to powers of courts. For instance, Parliament has the power to exercise the punishment for contempt of Parliament.
Right.
Yes. The point I'm making is that the majority are saying that the decision by the House, presided by the Speaker in their absence, was invalid. The minority are saying that we acted within the law, we followed the procedure, and that the thing is valid. You cannot overlook it. How are they going to sit down and bring the finance minister and say that the proposal, as far as we are concerned, what the minority did was invalid, so let us do it again? Unless they have followed the procedures, as my learned friend has said.
All right.
To have either revoked by the court or use the same process in Parliament to have it undone. If you undo it in Parliament, then you can proceed to go over it again. Not until that, we have to accept the fact that there has been a vote against the budget.
Oh, what a difficult place to be in this country at this time. I can't thank you enough. Musah Ahmed is head, Ahmed Legal Consult, and Julius Opoku-Adjei is head, Opoku-Adjei & Co. And we have been treating the subject, legality of toll suspension and budget rejection. I hope that we have given you some really very good education to help you in looking and understanding this matter. I'm Samson Ladi-Anyanini. This has been The Law. It's your legal light and your help law.